Welcome back to the deep dive. You're here for the shortcut, to get the critical, informed view on a huge news story without having to read thousands of pages yourself.
And this week, that is literally our job. We are diving into a monumental release. We're talking nearly 30,000 additional pages of documents tied to the Jeffrey Epstein and Ghislaine Maxwell investigations.
And this isn't just about a few new names or, some minor details. The sources we've gone through, they lay out a story of political friction, some pretty unprecedented legal claims, and a deeply, deeply controversial process.
Right, a process that has outraged lawmakers and survivors.
Exactly.
And the sheer volume here, the diversity of the files, I mean, we're talking photographs, video surveillance logs, internal FBI emails, legal filings. It all gives us this unexpected look into the internal mechanics of a federal investigation.
And how it all collides with wealth and power.
And the legal system, yeah.
Okay, so let's unpack this. Our mission today is pretty surgical.
Yeah.
We need to go past the headlines, detail exactly what information is now on the public record, especially with high-profile people. And then, and this is crucial, we need to analyze why the official handling of this has just blown up into a major controversy about transparency.
And we have to be, absolutely impartial here. Our job is to be guides to the material. We're reporting on the claims in the documents, the official responses, and the laws around the release. We're sticking purely to the documented facts.
Let's start with the rollout itself, because before we even get into the content, the way the Department of Justice handled these 30,000 pages, it's a story in its own right, a really chaotic one.
Chaotic is definitely the right word. To give you a sense of scale, 30,000 pages isn't a batch, it's a library. And like you said, it's not just legal paperwork. Our sources confirm it's a mix of evidence photos, surveillance reports, confidential correspondence between prosecutors, FBI files, and a ton of internal DOJ emails.
And the sources really dig into what happened right after they were first posted. It sounds like a procedural disaster.
It was far from a clean release. The sources describe this really confused process where the files go online, they're available for a little while, and then they're just pulled down.
With no explanation.
No public explanation. Then later, they're reposted. It just happened.
When you're dealing with information this sensitive, why does that procedural chaos, the posting, the taking it down, why does that matter so much?
Well, what's fascinating here is the immediate loss of public trust. When a government agency seems like it can't even control its own release process, it immediately raises questions. Are the contents being curated? Are they being managed for some other reason?
And it wasn't just the pull-downs. There's the redactions themselves. We're not talking about, blurring out a victim's name. Some of these pages are just solid black blocks.
Exactly. Pages that are entirely blacked out. Zero information. And critically, no explanation for why that specific content is being withheld. In a fight about transparency, that silence, it just reads as deliberate concealment.
Okay, so let's dive into the actual internal documents. There's one detail, it's from an internal email, that seems to have just dramatically expanded how big people thought this investigation was.
That would be the reference to 10 alleged co-conspirators. The sources point to a specific FBI email from 2019 where this group is discussed internally.
10 alleged co-conspirators. I mean, that's not a couple of assistants. That implies a network.
It absolutely shifts the focus. Now, to be perfectly clear for everyone listening, the names of these 10 people were not disclosed in the released material.
Right.
But the fact that federal investigators were even talking about a group that size, it just reframes the public's understanding of how wide Epstein's operations might have been.
That number, 10, it really does move the focus from, a couple of bad actors to a potential systemic failure, or at least a much bigger conspiracy. And speaking of powerful figures, our sources spend a lot of time on how these files intersect with President Donald Trump.
And this transition, it requires us to be crystal clear. The source material emphasizes a huge disclaimer right up front. President Trump has not been charged or accused of any wrongdoing in connection with Epstein based on these documents.
That is paramount.
What we're discussing are references, claims, and internal notes. They are not legal findings.
Okay, so with that understood, let's look at the first reference. It's a very serious but uncharged allegation that pops up in an FBI file.
Correct. The file includes a rape allegation that was brought forward right around the 2020 presidential campaign. But the context is everything.
Okay.
The files have no supporting evidence for this claim, and it was never charged. It's basically an unverified tip that was logged in an FBI file.
So it shows how wide a net they were casting for information, basically.
Regardless of its validity, yeah.
Then we shift to a totally different kind of document, a formal court filing. And this one details an account from a woman identified only as Jane Doe.
That's the Mar-a-Lago account. In her filing, she alleges that Epstein took her to Mar-a-Lago back in 1994 when she was 14 years old.
And what does her account, as it's written in that document, say happened?
Well, the document alleges that Epstein introduced her to Donald Trump, who owned the property at the time. After the introduction, Epstein allegedly made a crude remark. The document then states that Trump allegedly smiled and nodded in response.
And how did she say she felt?
The claimant said she felt uncomfortable, but also said she was too young at the time to really understand the full weight of it all.
So just so everyone listening can process this, we are talking about a formal claim made by an alleged victim in a legal document. But that's very different from a legal finding, which would require evidence.
That is exactly right. This claim is now in the public sphere because the document was released, but it was never tested in court.
So the release gives us the claim, but none of the context of verification.
That separation is vital. These are allegations put on the record by a claimant, not verified facts from the investigation itself.
Okay, the third reference moves away from allegations entirely. This is about travel logistics, a Department of Justice email from January 2020 discussing flight records.
Right, and this is maybe one of the more concrete details about their connection. This internal email discusses flight logs from Epstein's private jet. It specifically states that the records showed Donald Trump was listed as a passenger on at least 8 flights between 1993 and 1996.
And the email also says that this number, 8 flights, was actually more than investigators had previously known about.
Exactly. It suggests a more substantial association, at least in terms of travel, than maybe the public or even the investigators first knew. But, and this is a common theme, the email is partially redacted.
Of course.
So while we know investigators found this, the DOJ hasn't publicly confirmed or, elaborated on that flight data.
So with these 3 things out there, the uncharged allegation, the Mar-a-Lago claim, and the flight data, the DOJ felt it had to say something. What was their defense?
Their response was forceful. Unusually forceful, I'd say. They stated, and I'm quoting, "Some of these documents contain untrue and sensationalist claims made against President Trump that were submitted to the FBI right before the 2020 election."
Okay, so that's clearly pointing at the uncharged allegation. But they didn't stop there, did they?
No, they broadened it. The DOJ called the claims, in general, unfounded and false. And then they added the strategic point that if the claims had any credibility, they would have been weaponized against President Trump already.
Which suggests they were looked at and dismissed.
Right, as either politically motivated or just having no evidence. But despite that really strong language, the DOJ created this critical ambiguity.
That's the key problem, isn't it?
It is. The statement never specified which documents they were calling unfounded and false. Was it just the uncharged allegation? Were they also denying the Jane Doe claim? Or the flight log data from their own internal email? That ambiguity leaves everyone just guessing.
And that kind of strategic ambiguity itself raises questions. I mean, why issue such a strong denial if you're not going to be specific about what you're denying?
Well, it allows them to discredit the most sensational stuff without having to confirm or deny the more logistical things, like the flight logs. In a high-stakes political situation, a broad denial can limit the immediate damage without creating a paper trail you have to defend later. The classic risk management move.
What about President Trump's personal reaction? He talked about the files at his Palm Beach club.
Yeah, but his focus wasn't really on the specific claims against him. He talked more about the general consequences for other people. He said he was concerned about the reputational damage to other people that really had nothing to do with Epstein. He sort of cast himself as being concerned for everyone else caught up in it.
And he also wove it into his larger political narrative, I imagine.
Absolutely. He basically framed the media coverage of the files as a distraction, something that was overshadowing what he described as the accomplishments of his administration.
Which brings us to what might be the most crucial part of this whole story for the survivors and for transparency advocates. This huge fight that has erupted over the release process itself. Congress actually passed a specific law for this.
They did. This whole release was supposed to be governed by the Epstein Transparency Act. And this act was Congress trying to force the DOJ to release all the materials at once, with very, very limited redactions.
And what were the only allowed redactions?
Just 2 things. Protecting victims' identities or shielding information related to an ongoing active criminal investigation. That's it.
So the mandate was clear, get it all out, right now, with minimal filtering. But sources say the DOJ's chaotic, piecemeal rollout is getting huge pushback from the very lawmakers who passed the bill.
Yeah, lawmakers are alleging serial noncompliance. The big points of friction are the staged releases, not doing it all at once, and those unexplained redactions we talked about. And the files being taken down and put back up, that just makes it all worse.
And the sources have a really specific example of this alleged overreach with the redactions.
They do, and it gets right to the heart of the legal fight. The most criticized example is the redaction of the names of attorneys inside internal DOJ emails. Lawmakers are arguing there is zero justification for that under the Act.
Right, because redacting a lawyer's name doesn't protect a victim, and it doesn't shield an active investigation.
Not at all. So critics are arguing that the DOJ is exceeding its authority and just substituting its own judgment for the will of Congress.
And that turns a legal release into, what, a constitutional conflict?
Pretty much a fight between the executive branch and Congress over oversight and transparency.
And we can't forget the human cost in all of this. For the survivors, this mess isn't just a legal headache.
No, it's a profound source of frustration. They've said that this chaotic, staged rollout undermines the entire promise of transparency. They feel that if the information isn't released fully and clearly, then justice is still being hidden, and accountability is just being delayed by bureaucracy.
So what does this all mean? I mean, this latest release, these 30,000 pages, they really highlight this ongoing tension between the public's right to know and the controversial handling of that information by the DOJ.
The information's out there now, but its context, its verification, that's all still fighting to catch up.
So let's review the two core takeaways for you today. First, specific, unverified allegations and internal records about a powerful political figure, President Trump, are now in the public domain, and it requires all of us to carefully distinguish between a claim and a legal fact.
And second, the disclosure process itself is being actively challenged by Congress and by survivors. They allege the DOJ is failing to comply with a direct congressional mandate for full, immediate transparency.
Which leaves us with a final thought.
It does. And this is a question for you to think about. If a bipartisan mandatory act of Congress requiring total transparency can be, it seems, skirted by the executive branch, through things like ambiguous denials and redacting even non-sensitive details like an attorney's name, what does that ongoing concealment tell you about the power of the institutions trying to control the narrative? And I guess how much unknown, legally sanctioned information still remains hidden from all of us?
A lot of questions still remain. Thank you for joining us for this crucial deep dive into the source material. We will see you next time.